for the Southern District of New York for a number of years, becoming the head of the securities fraud division, and then practiced white-collar defense, first at Mudge Rose and then at Fried Frank, before becoming in 1996 a federal district judge in the Southern District of New York. As a judge, he's authored more than 1,500 judicial opinions, co-written 5 books, published more than 140 articles, and delivered over 600 speeches. But that's in your program, and I thought just to give a little texture to the character of our next speaker, I thought I would quote the first paragraph of an article written in the Financial Times. The author met up with Judge Rakoff for lunch, and she writes, "Jed Rakoff has a reputation for speaking his mind, but he refuses to tell me where he'd like to go for lunch. As one of America's best-known judges, he says he cannot be seen to endorse one restaurant over another. Nor will the Financial Times be paying for his meal, since judicial ethics forbid him from accepting hospitality. The fundamental rules of lunch with the Financial Times have been broken, but Rakoff is not a man who readily submits to prescription, so I don't make a fuss." Without any further ado, ladies and gentlemen, the Honorable Jed Rakoff.
So, thank you very much for that very nice introduction. Brandon, how much do I owe you for lunch? Yeah. No, it's very nice to be here, and it's such a diverse audience and such an interesting program. And what I'd like to talk a little bit about is how judges deal or fail to deal with forensic science, how judges deal or fail to deal with statistics, and how judges deal or fail to deal with the interplay of forensic science and statistics. And I should tell you at the outset that most judges know beans about science. I was an English major. Most of my colleagues were either history majors or poli-sci majors. Yes, we had to take that one required course freshman year in science. I took something that was popularly called physics for poets, and the poetry was great. And then, of course, we all went on to law school, and that convinced us even more that the last thing we ever wanted to spend any time on was science. And yet, science pervades the legal system, from patent cases to environmental cases to civil commitment cases to sentencing to toxic tort cases to class actions. I could go on and on. And it is impossible, genuinely impossible, for a judge today to deal with his or her caseload without getting scientifically savvy to at least a moderate extent. It's part of the job. Where judges have been, in my view, least successful in fulfilling that challenge has been in the area of forensic science, and perhaps most especially in the area of the statistical aspects of forensic science. And this, in some ways, is kind of surprising. First, because forensic science, as the sciences go, is not, as they say, rocket science. It's not without its complexities, but it's not the most difficult science to understand. And secondly, and more importantly, in the last 2 decades, very serious questions have been raised about whether forensic science is science at all. And a lot of those questions are getting played out, or should be played out, in the courts of the United States. Those questions arose, ironically, in part because some pretty darn good science, DNA science, got introduced into the courts about 2 decades ago. Originally, DNA, unlike most forensic science, which for the most part was developed in police labs, DNA testing was developed by hard scientists, so to speak, and it was then brought over and was proved to be a very helpful tool both for convicting the guilty and exonerating the innocent. And the result was that it was so much more rigorous than bite marks or foot marks or even the alleged previous gold standard fingerprinting, that people began to take notice that this was a more serious kind of science than the forensic sciences judges were used to seeing. And then, even more mind transforming, there came along the Innocence Project, and the Innocence Project began to use DNA to show that people who had been convicted beyond a reasonable doubt of the most serious crimes, murder and rape for the most part, were in fact factually innocent. And in something like 45% of those cases, forensic scientists had testified at the trial to say that they were guilty, and had said, yes, that hair sample that was found on the victim's clothing came from that defendant, and I am sure to a reasonable degree of scientific certainty that it was only that defendant and no one else. And that was wrong. Wrong not just once in a while, but wrong repeatedly. There's now been exonerated about 350 people by the Innocence Project, but an even greater number, about 2,000 people overall in the United States since all this got underway. And somewhere between 35 and 40% of those cases involved forensic scientists testifying that the guy was guilty. So it was not lost on judges and on others that there was a problem here. So how did government respond? Well, the first to respond was the legislative branch, Congress, and what they did was they asked the National Academy of Science to take a look at all this. And in 2009, as many of you know, the National Academy of Science issued a groundbreaking report, co-chaired, I might add, by a very famous federal judge, Harry Edwards. Basically it said that with the exception of DNA, most of the forensic sciences were very problematic, primarily for 2 reasons. First, they had not been seriously tested, not tested in a way that science is normally tested through carefully controlled experiments. And second, they involved a considerable degree of subjectivity. And whenever you have subjectivity, of course, you have the chance that 2 different people applying the same so-called methodology will come to very different conclusions. And that may be helpful or not, but it's certainly not serious science. So in reaction, I should say that the 2009 National Academy of Science report recommended that a national commission be established that would set standards and undertake experimentation for the forensic sciences, an independent body of serious scientific background that would really try to rectify these problems. That has never occurred, and it's a great shame it's never occurred. I agree with the National Academy of Science that that would have been the best solution. But government did react. The executive branch in particular did a number of things. First, one arm of the executive, NIST, the National Institute of Standards and Technology, I have to always look at the title because back when I was born it was called the Bureau of Standards, but in any event, formed something called OSAC, an organization of scientific area committees, and they have done some good work. not without controversy, but some good work in trying to come up with some standards. A lot of standards that they've either promulgated as drafts, a few have been already finalized, but they don't get to the more fundamental questions raised by the National Academy of how valid is the underlying methodology, and that's not their bailiwick, but they have done some good work. A more promising effort, at least initially, was the creation of the National Committee on Forensic Science, National Commission on Forensic Science, and this was purposely designed to include all the players. So you had lab technicians, but you also had hard scientists. You had prosecutors, but you also had defense counsel. You had a very wide range of people from various academic disciplines. You had a couple of state court judges. You even had one lonely federal judge, namely me. It was a very broad-based commission. Now, there are problems when you have a commission that is so broad-based, which is that it's difficult to reach a consensus. Nevertheless, the commission did, over the course of its 4-year term, promulgate 49 different recommendations, and a fair number of them were adopted by the Department of Justice. And indirectly, they also influenced state court practices. It's well to remember, by the way, that in the United States, most criminal prosecutions occur in the states. So the role of the federal government is in some ways to set models or to try out experiments, but the real action ultimately occurs or fails to occur in the states. But the National Commission's recommendations were, as I say, largely adopted by the Department of Justice, but also filtered down to a number of states. On the other hand, it was hard for a commission that broad and representing so many competing interests to really come to a consensus on some of the more difficult issues, including the statistics relating to forensic science. So here's what the commission did and failed to do in that regard. The commission recommended almost unanimously that theforensic scientists who testify in court stop using this formulation, which had become virtually universal, that their conclusions were made, quote, to a reasonable degree of scientific certainty. Now, any scientist will tell you there's no such thing as scientific certainty, and certainly not in this area. Much of 20th century, 21st century science is probabilistic by its very nature. And so this was an inaccurate phrase. It was also a very misleading phrase because it led the jury or the judge to believe that science had determined with finality the particular opinion being given, and so who could possibly question it, which was, of course, not true. So the commission recommended doing away with that formulation. That was adopted by the Department of Justice. It's filtered down now to a number of states, and that was a positive move. On the other hand, when the commission got around to trying to deal with what should be said instead, like what should be said about error rates where they're known, or even more importantly, because in most of these cases you don't know the error rate, what should be said about the absence of known error rates and what doubts that may create for the usefulness of this testimony, the commission was unable to come to a consensus. They were moving perhaps towards a consensus. In the last couple of meetings before their conclusion, there was some indication that eventually they would come out with some pretty good recommendations, but even though a majority of the commission asked that their term be extended, the current administration decided to shut it down, and that's where it's remained. Another final thing that the executive did, and in my view, perhaps the most important, but also the most controversial, was right out of the White House, where the President's Council of Advisors on Science and Technology, a group called PCAST, issued a report in the last months of the Obama administration that was very hard-hitting. This was a report put together by hard scientists led by Eric Lander, a very distinguished scientist in his own right. And basically what it said was that with the possible exception of some efforts by the FBI in the area of fingerprint evidence, there had been no meaningful improvement since the 2009 NAS report, and most forensic science, with the exception of DNA, still had not been seriously tested in a scientifically rigorous fashion. Most of it still involved a great deal of subjectivity. The report did point out ways that this could be cured, steps that could be taken, but it was received rather negatively by the Justice Department, by the Organization of Police Chiefs, and by various other groups, because it said, in my view, accurately, in the last nearly decades since the report came out, there has been very little improvement on the most fundamental things that you need to make this a science, which is testing and objectivity. As I say, the PCAST report was not met happily, and for whatever reasons, some of them political, but some of them also non-political, it has perhaps aroused more controversy than might have been hoped, but in any event, it still represents, in my view, the path of the future. Now, I've talked about what the executive did, I've talked briefly about what the Congress did. Let's talk about the one group that you would think would be most hands-on in this area, because this is where forensic testimony arises, which is in the courts. So you go back to before 1993, and the test for the admission of scientific evidence prior to 1993 was something called the Freud Test, which grew out of a DC Circuit case of many decades earlier. And the test basically was that if it's generally accepted in the scientific community, it's admissible. The problem with this test, among other things, was that over time, the definition of what the relevant scientific community was had gotten narrower and narrower. So if you wanted fingerprint evidence in, the relevant community was, is it accepted by fingerprint examiners? If you wanted handwriting in, was it accepted, handwriting analysis, was it accepted by handwriting analysts? So virtually everything came in, very little was excluded. Judges tended to sort of comfort themselves by saying, well, we have an adversary system. If it's really not good stuff, it'll be the subject of cross-examination. But this was, in my view, and in the view of the Supreme Court of the United States, an evasion of their responsibility. And I say evasion, let me give you just one example from that period, and I could give many. This is a case called People v. Collins out of California, and the ultimate decision was that of the Supreme Court of California in 1968. The California court, the Supreme Court, describes what happened in the trial court. I should mention this was a simple street robbery. A woman was walking along. Another woman comes up, grabs her pocketbook, pushes her down. That woman sees fleeing from her a young blonde girl with a ponytail. The young blonde girl gets into a car with a black man who's got a mustache and a beard, and they drive off. And there were two eyewitnesses, the victim and someone who saw the girl getting into the car, and their observations were very limited and they weren't very good. And so, as the Supreme Court of California says, quote, in an apparent attempt to bolster the identifications, the prosecutor called an instructor of mathematics at a state college. Through this witness, he sought to establish that, assuming the robbery was committed by a Caucasian woman with a blonde ponytail who left the scene accompanied by a Negro with a beard and mustache, there was an overwhelming probability that the crime was committed by the two defendants. The witness testified in substance to the product rule, which states that the probability of the joint occurrence of a number of mutually independent events is equal to the product of the individual probabilities that each of the events will occur. The prosecutor then proceeded to have the witness assume probability factors for the various characteristics which he deemed to be shared by the guilty public and all other, by the guilty couple and all other couples answering to such distinctive characteristics. Applying the rule to these factors, the witness arrived at a probability that there was but one chance in 12 million that any couple possessed the distinctive characteristics of the defendants. Now, I don't know that much about statistics. Some of you may not, but you don't have to know very much to know this is junk. This is incredible junk. First, you have probabilities just hypothesized and assumed by the prosecutor. Second, there's no indication whether the factors are truly independent or whether they overlap. Common sense suggests that there are a fair number of blondes who have ponytails. What's amazing to me, but it was not so untypical of the period when Fry reigned, was this was admitted by the judge. It led to the conviction of the defendants. It was affirmed on the direct appeal, and it was only when it got to the Supreme Court of California that it was thrown out, and even then with a dissent. So this gives you an example of just how loose and not useful the Freud test was. So in 1993, the Supreme Court came along and issued the Dalbert decision. I should pause here to tell you something of great importance, which is there's a very real debate over whether it should be pronounced Dalbert or Dalbert. Mr. Dalbert is on record as saying both. The one thing you can't call it, as some of my Francophile friends do, is Dalbert. You'd be pretty much a snob to do that. But in any event, I'm going to call it Dalbert. The Dalbert test said, Dalbert opinion said, that judges have an obligation to give a rigorous analysis before admitting any kind of scientific evidence, not just forensic evidence, but any kind of scientific evidence. They should look at a number of factors, such as whether it's been tested, whether it's been peer-reviewed and the subject of publication, whether there is a known error rate, and if so, is it an unacceptably high error rate? And if there's not a known error rate, why not? And also whether it's generally accepted, but generally accepted in the broader scientific community and not in the very narrow version that Fry came to represent over time. This was a groundbreaking decision, and in many areas, it was quickly adopted. There were a lot of cases, mostly civil cases, where Dalbert came into full play right after it was promulgated. But the great exception was forensic science. In 2002, a study was done by a bunch of professors at Scripps College of all 700 plus cases that had come down since Dalbert in which forensic science had been challenged under a Dalbert standard. And I should point out that 37 of the 50 states adopted Dalbert, so it became the law. The few states that didn't adopt it, including my own state of New York, were primarily states where there was a very strong plaintiff's personal injury bar, and they like to get questionable stuff into their personal injury cases. That's my cynical analysis of it. But most states did adopt it, and the folks from Scripps looked at all 700 plus cases that had been decided between the time Dalbert came down and 2001. They published in 2002. And they found that in over 95% of the cases, judges still admitted forensic science under a Dalbert challenge. Now, you know, maybe that's because all the science was great, but that is in very distinct contrast to how those same judges handled most other kinds of science that were presented under a Dalbert challenge in civil cases. And I'll get to another statistic in a moment which suggests strongly that the judges were not exercising their normal role in those cases. Now, maybe you think it's because judges don't understand science. You know, that's often said. I may mention that at the beginning, but I want to qualify that. What most judges are quick studies. In fact, that's what most trial lawyers are. It's really part of the game. Anyone who is a trial lawyer will know what I mean. When you get a new case, you know nothing about the area. You're completely ignorant. By the time that case goes to trial, you are the world's expert on that area. Now, once the trial's over, you forget it the next day. But it is the nature of being a trial lawyer, being a litigator, that you're very good in getting deeply involved in the minutiae and the technicalities of whatever is involved, and that includes the science. Well, judges are, defrocked trial lawyers, and they have that same tendency, and I have seen firsthand my colleagues develop tremendous expertise in particular areas of science on a very quick basis. There's also a provision in the federal rules that you can have court-appointed experts to assist you. So I don't think it's really true that the fact that most judges don't have a scientific background really prevents them from being good at analyzing scientific issues in particular cases. And as I mentioned before, most forensic science is really not that difficult compared to many other kinds of science. So why do you think there was not this usefulness, this really serious attention to forensic science after Dalbert came down? One reason, of course, is this study was done before the NAS report came out in 2009, so it was the deficiencies of forensic science were not on the front page, so to speak, for most judges. But another factor, I think, to be utterly frank, is the pro-prosecution bias of most judges. The same report said that where the defense had offered forensic science testimony in the years between 1993 and 2001, the defense proffers were rejected in 92% of the cases, also under a Dalbert challenge. So here are judges who are saying in 95% of the cases, the prosecution's forensic science comes in, and in 92% of the cases, the defense forensic science does not come in. You know, there may be good reasons for this. It is true that government forensic experts are often much more adept. They testify regularly. They're much better explaining what they do than defense counsel. It's also true that because most defendants are indigent or at least not rich, they can't hire terrific experts unless someone's willing to do it pro bono. It's also true that most judges, particularly in criminal courts, are former prosecutors, and they're used to introducing, when they were prosecutors, they introduce this testimony. I was a federal prosecutor. I'm very familiar with how you become used to certain kinds of testimony coming in, and you take that to be the way things are. But with all that said, the simple fact is that in the years immediately following Dalbert, essentially no effort was made by state or federal judges to apply Dalbert seriously to forensic science. This is, I think, also a function of a more fundamental issue in the American legal system. We don't have a civil law system, the system they have in Europe, where everything is reduced to a code. A lot of U.S. law is judge-made law, and that requires very heavy attention to stare decisis, to precedent, because if judges are going to make the law, you're not going to have predictability unless precedents are given great weight. That's built into the system, and there's a lot of positive things to be said for it, but in this area, it operates very negatively because all the precedents allowing in all this stuff were set during a time when Fry was applying and in which Fry was not really seriously taken, and so almost anything came in. And I'll give an example of what I'm talking about in a case that came down 1999 from the Supreme Court of Kentucky. The question, Kentucky had adopted Dalbert, and now there was a case, a murder case, in which there was found in the fist of the woman who was murdered one hair of presumably the person she was fighting for her life with, and the government was prepared to offer testimony, and ultimately did offer testimony, from a forensic scientist that hair unquestionably came from one and only one person in the world, namely the defendant. The defense lawyer raised a Dalbert challenge, and the trial court rejected, said, I don't even have to hold a Dalbert hearing. Everyone knows hair analysis is good science. By the way, the studies indicate quite a high error rate for hair analysis, but presumably he didn't know that at the time. The case went all the way up to the Supreme Court of Kentucky, which affirmed in the following language, quote, evidence of hair analysis by microscopic comparison has been admissible in this Commonwealth for many years. Although we have never specifically addressed the scientific reliability of this method of hair analysis, we must assume that it at least satisfied the Freud Test of general acceptance, for otherwise the evidence would never have been admitted in the first place. Think about that sentence and what a non sequitur that is. Continuing in the quote, the absence in our previous opinions of any in-depth analysis under the general acceptance test was probably due to the overwhelming acceptance of this procedure as a reliable scientific method for the past 50 years. Based upon the overwhelming acceptance of this evidence, trial courts in Kentucky can take judicial notice that this particular method or technique is deemed scientifically reliable, close quote. In other words, well, we've never actually ever looked into whether hair analysis is scientific. And we've got a whole new standard now that's much more rigorous, Dalbert, that we've adopted here in Kentucky. But not only are we not going to try any scientific analysis under Dalbert, we're not even going to permit a Dalbert challenge because we are going to take judicial notice. Judicial notice, for those of you who are not lawyers, means a fact is so well established that no reasonable person could possibly contradict it. It's things like 2 and 2 equals 4. So we are going to allow judicial notice that hair analysis is scientifically reliable. I mean, forgive me, I love the state of Kentucky. It's a beautiful state, but this is junk. This is total junk. But it was in part the dead weight of precedent that was operating. Has this changed in the courts since the NAS report, since the National Commission, since the PCAST report? There has been no statistical study done similar to the Scripps study, so I don't have any data to present there. But reading the cases, I think the answer is only a little. I'll give, again, the follow-up from Kentucky. Because after the case that I mentioned, there came out all sorts of reports that were particularly critical of hair analysis as being one of the more error-prone forms of forensic science. So in 2013, based on all that, another defense counsel in Kentucky sought to reopen the question of whether there should be a Dalbert challenge to hair analysis. And in the case of Meskimen versus Commonwealth, a 2013 opinion of the Kentucky Supreme Court, the court said no, precedent rules. And here's what they said specifically. In this case, the Commonwealth offered evidence that has been admissible in the state of Kentucky for many years. Microscopic hair analysis is scientifically reliable, and we therefore do not require that a Dalbert hearing be held with regard to the admittance of such evidence. Now, maybe they felt a little guilty about that in light of all that had come out, so they added the following, which I would characterize as passing the buck. Quote, with that being said, the state of scientifically accepted evidence is ever-changing, and what is scientifically acceptable today may be found to be incorrect or obsolete in the future. In the present case, the trial court correctly took judicial notice of the acceptability of scientific methods, but this is not a rule that is set in stone and is subject to change with scientific discovery. It is up to the trial courts to stay abreast of currently accepted scientific methods, as they are the gatekeepers for the admissibility of evidence. Therefore, even though case law may be in acceptance of a certain method of analysis, it is the trial court's duty to ensure that method is supported by scientific findings, or at least not seriously questioned by recent reputable scientific findings before taking judicial notice of its acceptance. That, of course, was not the case here, thus we find no error, close quote. Right. So I don't want to end on a totally pessimistic note, but my basic point is that the courts are not doing a good job of analyzing forensic science, including the statistical aspects of it. There are things that could be done and perhaps are being done to change that situation. The defense bar, which for many years on the criminal side neglected this whole area in a way that the civil defense lawyers did not, and there were many, many, many more civil challenges to scientific evidence under Dalbert than there were criminal challenges, and that's true even today, partly as a function of money, but nevertheless, defense counsel are beginning to get better educated. Department of Justice, to its great credit, has started educating some of its prosecutors on some of the pitfalls of forensic science, and that's very laudable. The academic community and scientific community has begun to get more involved through amicus briefs and otherwise in bringing to the attention of the courts the problems that exist in this area. Nevertheless, I think it is really beyond question that the courts of the United States have not even begun to analyze, scrutinize, evaluate the admissibility of forensic science. And as long as they fail to do that, more innocent people will be convicted on the basis of bad forensic science, and I suggest to you that that is morally reprehensible. Thank you very much.
So what do you think would be something that could be done now to get more science into the courtroom or get judges better in tune with this?
There we go. Okay. I think the standard of review could be changed so that there are more reversals. Nothing focuses the mind of a trial court more than being reversed by a court of appeals. The standard right now is abuse of discretion, a standard that most trial courts can easily satisfy. So the standard were changed, for example, to de novo review, where the Court of Appeals did its own analysis, and then there were reversals. I think you would see trial courts paying more attention. So that's, in the very short run, I think that would be my suggestion.
So start with the courts of appeals.
Yes.
More questions? Yes. The mic is coming.
Do you think that the courts in general even know how to evaluate scientific evidence?
Yes, why not? As this is, as I, if I, an English major for God's sake, could come to understand at least the basics of this stuff, I have no doubt my colleagues can. So one of my colleagues, Judge Sweet, had the very interesting case involving whether you could patent genes, and both artificial and non-artificial genes. His background, he was a history major. He spent many, many months getting versed in the law regarding how genetics operates and how it plays out in this particular context, and he wrote a 150-page opinion. It was initially reversed by the Federal Circuit, which is supposedly a specialized court that knows all these things, but the Supreme Court of the United States reversed the Federal Circuit and reinstated my colleague's opinion saying it was a much better understanding not just of the law, but of the science. So I do think courts are able to evaluate this stuff and evaluate it well, but it takes work.
More questions? Yes. We have two hands, Rebecca and then Henry.
So I have a question about the other areas of the law where you've seen something like this happen, where there's precedent, but then a relevant law changes, but then because of the precedent under the old law, things remain. Is that something that has happened or is common to happen state or federally in other areas, or is this a pretty unique situation relating to forensics and Dalbert where that precedent would remain despite a change in law?
Well, I think there's no single answer to that question. Those who like the common law system of proceeding, and I'm one of them basically, like the fact that it over time can adjust to changes because you're not wedded to the words of a particular code. And there's a lot of places where judge-made law actually can adjust to entire changes in society. On the other hand, if courts are preconditioned for whatever reason to dig in their heels, and I'm afraid I think that's true when it comes to forensic science because of the pro-prosecution bias of many courts, then they can use the precedents to say, oh, we're stuck with the precedent. So I think it varies with the situation.
Thank you. Your Honor, the observation that you made to get more favorable or frequent decisions on Dalbert hearings that would exclude questionable forensic evidence relies in so many ways upon the current practice of requiring gross abuse of discretion on the part of the trial court judge in order for the appeals court to reverse. You're suggesting, from what little I know, and I'm not an attorney, a change in the fundamental precept of the basis for appellate decisions. How does one go about the process of encouraging appellate courts not to be limited to gross abuse of discretion, but to undertake de novo review of the merits of the case?
So there was nothing inherent after Dalbert first came down in abuse of discretion being the standard of review. It was open to any of several possibilities, and it was the Supreme Court that decided it should be abuse of discretion in a subsequent series of decisions. And of course, that means that that standard is still in place until the Supreme Court changes its mind. However, the Supreme Court made that decision in an across-the-board fashion relating to all scientific evidence and all Dalbert challenges, and they did not attempt to distinguish certain kinds of science from others. I think, and I'm just thinking off the top of my head here, but I think at least an argument could be made that in the case of forensic science, given what we now know, which the Supreme Court certainly did not know in 1993 when they decided Dalbert, that a greater scrutiny could be given by higher courts. Even if that were not the case, abuse of discretion is to some extent a loaded term. And I've seen cases where the higher courts have given it a more narrow interpretation and cases where they've given it a more broad interpretation. So there is a little bit of play right there. But the best change would have to come from the Supreme Court.
I believe mine is more of a comment. So I supervise a unit in a federal crime laboratory, and I have embarked on a mission, I would say, to try to promote some sort of change in the forensic sciences, and in particular fingerprint examination. And I've been withered to see the resistance to it, and so that won't let me give up. But I want to say that I appreciate your candid remarks. I also sometimes lament the fact that I find myself showing up to conferences with a lot of defense attorneys because I find myself actually on my knee pleading for them for the change, which I think is a bit backwards. And so your comments resonate with me well. And so I thought I would really make the comment to those of you that attend UVA as law students and listen to the systemic challenges that we have in forensic sciences today and think about, don't just be succumbed by the system. Listen to the judge's comments and think about how you, as the next generation of attorneys, the next generation of judges, can help change this. It will not be simple, but forensic science reform has to take a concerted effort with all stakeholders of the criminal justice system. Us in crime laboratories, we bear the burden, but in and of itself, unfortunately, we won't be the sole one. So I'm on my knees pleading with each of you as well. As you continue through your education and begin practicing, consider these systemic challenges and commit to actually making that change within your own right as well.
Very good comment.
Some questions in back?
Your Honor, as far as at the trial level, before we even get to the Court of Appeals, from your side of the bench, what would you like to see defense attorneys doing so we don't even have to get to that point? Especially, certainly in my circuit, it's all pro-prosecution. What do you think would be most effective? What do you think judges, what do you think is the best tactic to take to try to get these scientific principles across?
So it does vary a lot from court to court and from area to area, as your question suggests. I am constantly amazed, though, at how few Dalbert challenges are brought. I think part of the reason is because defense counsel is often engaged in plea bargain discussions, and they don't think it would be helpful. As a former, after I was a prosecutor, I was a criminal defense lawyer for many years. I actually think that's bad strategy on their part. I think actually it gives them another tool to get a better plea bargain if that's what they're looking for. But I've had in my own court repeated cases where I can see just from my own previous cases that there's a clear challenge, Dalbert challenge to be made, and it isn't made, and it's not my role, except in the most extreme cases, to raise that kind of challenge. It is an adversary system. So number one is they need to make the challenge more often. Part of the problem there is economics. In the federal system, you can get an expert paid for with federal funds. In many states, that's not the case. And if you don't have your own expert, you're going to be at a considerable disadvantage. But I'll tell you, the thing that I think resonates with every judge, no matter what their biases, no matter what their backgrounds, and that is conviction of the innocent. So if you can early on bring to the attention of the judge you want to make a challenge before that this very kind of evidence in some other case led to someone who was factually innocent being convicted, and it was only 20 years later that that person was exonerated, I do think that has great force. When I was a prosecutor, I was one of those folks who believed the system almost never makes a mistake. We have all these protections, proof beyond a reasonable doubt, Fifth Amendment, you name it. The Warren Court had increased all those protections. And to me, it was utterly mind-boggling when the Innocence Project showed how wrong that assumption was. And I think that is not lost on other judges either. And so as a strategic matter, I think I would earlier on find a way to make known to the judge or before of a case or cases involving that specific kind of evidence that you're challenging that led to a false conviction.
I'm over here. You said that there's a distinction being made between civil cases and criminal cases in terms of the effectiveness of challenging scientific evidence under Dalbert. One other difference between those two contexts is the discovery process. I've long thought that if we had active discovery in criminal cases where you had required detailed expert reports that were publicly available, then the scientific community would be available to actually peer review those, and you'd have a much more effective opportunity to challenge it among defense attorneys. Do you agree with that? And then B, I guess, is there any movement among the states to require greater discovery and detailed expert reports?
So you're preaching to the choir, because the National Commission on Forensic Science, one of their specific recommendations was that the Department of Justice have the same detailed discovery in criminal cases involving forensic science testimony that they are required under the Federal Rules of Civil Procedure to have in civil cases. And the department largely, though not totally, adopted that. More recently, the National Criminal Rules Committee of the federal judges has begun considering whether to amend the Federal Rules of Criminal Procedure to require greater disclosure in forensic science situations than is presently required, again, using the civil disclosure as a model. There is the great irony, which many, many people have commented on, but I'll mention it anyway. In civil cases in the United States, we have the greatest pretrial discovery in the world. There's even the argument that we have too much because it's very expensive, but you get, in the case of experts, you get highly detailed reports, you get access to their files, you get a chance to depose the expert. You know everything you need to know to challenge that expert long before you go to trial. In criminal cases, virtually none of that happens. That must reflect our national consensus that money is more important than life. In any event, it is an irony deeply built into the federal rules and goes well beyond the question of forensic science. Nevertheless, the Federal Judges Committee on Criminal Rules is considering a change, so I hope that law school deans, just to take an example, might get involved and give their views to that committee. In terms of the states, wide variation. One of the states that's done the most in this area is Texas. Not a state often looked at as being in the forefront of these kinds of issues, but their Supreme Court and a judge who was on the National Commission, Judge Hervey, have done wonderful things to push for greater discovery in this area. New York has been more backward, but the new Chief Justice, Janet DeFiore, has recently come out with proposals to do more in that area. So there's a wide variation, and But I think there is a tendency to follow the lead of the federal government in this area. So I think how the federal government comes out will have a big influence.
Thank you. I wonder what you think. You've talked about changing the standard from abuse of discretion to de novo, but in one of the cases, follow-up cases to Dalbert, Kumho-Tyre, Justice Scalia had this concurrence where he said, if you don't apply the Dalbert factors in a way that actually ensures reliance, it might very well be an abuse of discretion. I wonder, on the one hand, what you think of that as sort of a containing influence or a channeling influence?
There is play there because all judges will at least nominally apply all factors, but then the appellate court could say they didn't seriously apply it because there is language in Dalbert and subsequent cases from the Supreme Court that the analysis has to be, quote, rigorous, whatever that means. So there is room there for the higher courts to be tougher under even an abuse standard. And by the way, it doesn't have to be, there are midway points between abuse and de novo, and so there are other possibilities as well here. The tendency I don't think I'm telling any tales out of school when I say that when judges, including appellate judges, and I've had the privilege of sitting by designation on appellate courts, get together, if they think the other evidence shows the guy is guilty, they will tend to ignore or at least not pay as serious attention to the forensic issues as perhaps they should. It's a terrible thing because it creates precedents that then cover cases where the forensic science was critical. But I think it's a natural human tendency. When I was a law clerk on the Third Circuit, and I sat in for just a minute, because usually the law clerks were excluded when the judges got together to decide a case, but I was there for just a minute, and a very distinguished federal judge, now deceased, who was renowned, in response to one of the judges raising some serious technical difficulty, said, "Yeah, but he's guilty, ain't he?" And that's human nature, and contrary to popular belief, judges are human, so you have to deal with that as well.
We have time for one or two more questions. Yes, right here.
Your Honor, you mentioned the stark differences between the resources available to the defense bar and the prosecution. Based on your experience as a prosecutor and your experience on the bench, are there other ways to expect reform from prosecution who have many more resources and oftentimes are the side to which the most problematic deference is given? I'm thinking, you mentioned Texas, and we talked about Innocence Project. Both of those are examples where something horrible had to happen before reform occurred. And I'd like to imagine that some prosecutors would be willing to reform before something horrible happens. So I'm wondering if you have any ideas about how to achieve that reform other than just someone had to spend 20 years locked up wrongfully.
So on the one hand, in my experience, 99.9% of all prosecutors want justice to occur, and in those cases where they have come to realize 20 years later that they convicted an innocent person, they are often incredibly contrite and feel guilt-ridden. I mean, these are not people who are setting out in any way, shape, or form to convict the innocent. But the nature of the adversary system is that you tend to, when you expend so much time and psychological energy in a particular area in promoting your client's point of view, you adopt it as your own. I'm always amused to see how some of my colleagues who are among the toughest prosecutors and always wanted the harshest sentences and so forth, and within a month of becoming defense counsel, all their clients were innocent. But what's going on there is, and you see it in civil cases as well, because the adversary system puts so much emphasis on your zealously supporting the cause of your client, in this case, the cause of the prosecutor, you tend to adopt the values of the prosecutor. Now, in theory, the values of the prosecutor are to do justice, and there are many famous attorney generals who've, said, our aim is not to convict, but is to do justice in every case, and so forth. But the reality is, once you become at all convinced that A, the crime was heinous, and B, the likely person is X, you're going to really start viewing things in a skewed fashion, and you can't really help yourself. So while I think there's a lot that can be done, and as I mentioned, the Department of Justice is doing some things to educate prosecutors more on the pitfalls of forensic science. That's one of the few really hopeful things that I think is going on. I don't think the solution is going to come from re-educating the prosecutors. Now, historically, the solution always came from the one neutral, the judges. For reasons that have nothing to do with forensic science, we have now designed a system where nothing happens in court, where 97% of all cases are plea bargained, and where the real determination of justice occurs in the privacy of the prosecutor's office when he's negotiating with defense counsel. And so I put greater stock in educating defense counsel about this and giving them more resources, because I have to look at the fact that it's in those negotiations that most determinations are made rather than in a court of law.
Why don't we pause there? Thank you so much, Judge. We'll take a 10-minute break and then start with the next panel. Do you need to have a little? Do you need a few more bites before you go, or do you have your cap?